This takes us to number 6, which are questions and discussions. Thoughts from what we heard today? Additional items you want to know or not know? Things you think you might be lacking on or wondering about? Dory in the next section, and I can move her up into this section. Yes, Andre.
So, Chief, we had an excellent presentation from Charlotte Golden regarding Janus and post-Janus. She indicated she's not a subject matter expert for the antitrust arm. We also heard that lawyers are special and that we have been in the business of regulating ourselves for quite some time. I'm wondering, do we need more information regarding the antitrust components that are at play here? And again, this is my first meeting, so I don't know what necessarily was brought to bear prior, but I'm thinking that that might be the puck that we should skate to.
I think that's a very good observation. I do want to remind people that Paula Littlewood will be presenting at our next meeting. Paula has worked in this area for a very long time, has spoken nationally about it to a variety of groups. When she was executive director, was working with a group of people here, sort of anticipating and thinking about the future. And so I think she will be able to bring a lot to the discussion. I'll ask Dory to follow up with Paula to ensure that she'll be covering that. If not, I think it would be good for us to look for sort of an antitrust expert, because it's really in the antitrust area that there seems to be the most concern, is about excluding market players from the market or limiting them, and how that plays out, and how a group like the dentists are viewed when they do that. So I think that's a great observation. We will follow up. We're also hoping that the Nebraska person will be able to join us virtually. There's another person who has done a lot of work and discussion, not so much on antitrust, but in sort of looking at this. We're going to make sure that's not duplicative. We're hoping not to have things that are duplicative, but we are wanting to be sure we're looking at it from the different perspectives. And that was partially, we had an excellent presentation by bar staff last at the first meeting about Janus and sort of the historical from Doug and Jean. And then in some ways, some of the associate dean's presentation was similar, but a little more understanding it from her perspective, looking at the unions and how that might be analogous or not analogous. So I'm really, and perhaps Paula will also sort of go through a little bit of a case law historical perspective. I'm not sure she has in other presentations that I've seen. So I don't think it hurts us to be refreshed a little bit each time, but I'm also wanting, given our limited time, to try to get sort of the educational foundation so that we can start looking at possible options or models, what's worked, what hasn't worked, what makes sense for us, because I think we might be able to focus in pretty quickly on 3 or 4 models and then kind of dig deep as to how they would play out, and then kind of have our sense of which ones we think would recommend sort of in a sort of a priority, perhaps. Dory.
Okay, so to that end, in terms of the arc of the work that you've been doing and the presentations that you've been seeing, I understood from the chief that Paula Littlewood as a national expert would be very important as perspectives go, and we'll ask whether she'll be able to cover both the antitrust perspective as well as some of the other considerations, including as other mandatory or integrated bars have reacted, either because of pending or threatened litigation or just proactively. I know that some jurisdictions are legislating a change to the bar structure. Others are exploring it pursuant to a judicial mandate of some sort. So those are topics that I would hope she would be able to address with this group. And then, as the chief referenced, if we are able to technologically host and can find a scheduling time, Nebraska to explain some of the nuances of their experience because they're such a hybrid model. They have some perhaps valuable lessons learned and or awareness of how different they are, which is to say they're also aware of how other jurisdictions are organized. So those are two topics that I thought would be helpful for next time. And I'm imagining that you may want then an opportunity to discuss amongst yourselves based on the considerations that you've been hearing, things that you think either sound like they might be worth exploring as recommendations for the state of Washington. And then to the extent that that discussion informs what more you feel as though you might want to know in order to, distill your recommendations to writing, my thought is we would regroup to some extent there. And finally, because what we would ultimately want to package for the Supreme Court's consideration are some lucid recommendations along with implementation considerations, it becomes important, depending on what your recommendations are, that if this, then how would we get from where we currently are to that? What would be the implementation plan? If, for example, you heard discussion about the broadness of the mission is worthy of scrutiny for purposes of Keller computations, then we want to go to the foundational documents for that and examine whether that's properly scoped. And if not, part of the recommendations in terms of the implementation plan might be recommendations for pursuing a change there. Maybe some of that would be legislative change, court rule change, bylaw change, whatever goes into ultimately the implementation of what this group's recommendations turn out to be are additional considerations that we'd need to explore.
Fred and then Hunter.
I'm not sure whether we're on agenda item number 6 or 7, but
We're combining them.
okay. I thought, in my mind, I thought they combined well too. I want to throw something out, not as an argument, but as something to consider as we're looking at structure. My reading of the antitrust cases and listening to the dean from CLU, the associate dean here, has sort of clarified some of my thoughts on this. And for discussion and to consider one structural change that could reduce the chances a federal court would find our structure being unconstitutional would be this. Then I look at the North Carolina Board of Dental Examiners case, and a real big issue in that case was that there was no oversight by any public official. Now, that public official can be the legislature or it can be an elected Supreme Court. Either of those count. If we're going to have an oversight of the bar by the Supreme Court, two things to consider that come out of the 2014 task force report, and there was lots of things that were suggested there, but of the dozens that they suggested, two that we should consider, which I think gets rid of that North Carolina board case problem, are as follows. One would be that amendments to the WSBA bylaws should be approved by the Supreme Court. And the second one is that the dismissal of the WSBA executive director or the chief disciplinary counsel should be subject to veto by the Supreme Court. If those two things are in the hands of the Supreme Court, ultimately we have oversight by a public official. So those are easy things to do that would eliminate some constitutional objections. Thank you.
So I think what you were describing with respect to the antitrust considerations is to the extent that active market participants are involved in the regulation, and we therefore trigger these antitrust considerations, the obligation is for the regulation to be pursuant to a lucid state policy, and then for that oversight function to be vested in a public entity. And you're suggesting that a way to accomplish that final prong is to amend bylaws so that the Supreme Court has approval, and then prescribe that certain staff changes, especially the executive director and the disciplining council, might need to be Supreme Court approved.
I think you've stated about 90% of what I meant, and the slight variation would be is I'm not sure that I'm advocating it right now. I'm throwing it out for consideration. From what I've heard up to this date, that may very well work. But what I'd like to do is I'd like to point it out there. I'm not voting one way or another as this task force or this work
Understood.
group to do it. But I think it's worthy of discussion. Thank you.
Paul?
And I guess as a response to that, I would say that we have an integrated bar, and it's roughly, in my view, and probably the view of many members, half regulatory, half professional association. And over the years, consistent with things like those statements in the task force report, the members have felt increasingly disenfranchised and disconnected from the governance and leadership of the bar. So that is sort of an advocacy of more of that. If there's any hope of keeping the bar integrated, those kinds of proposals I think would be fatal to maintain the integration of the bar. I think that a lot of members do feel very disenfranchised, and the idea that the Board of Governors would have no authority over the leadership of its organization, consistent with the statute, the Bar Act, consistent with the bylaws. I think that just drives this bar toward bifurcation, and in my view, bifurcation looks a lot less like the bar than you have right now. A lot less. You have the professional association side that, if it's pushed that way, I kind of hope just walks away, just says, done with this disenfranchisement, done with this, not having any say, and just goes off and does its own thing. And the licensing regulatory discipline function is a very narrow creature, I hope. So there's a lot in between that gets lost if you drive this to a purely, now, and one thing I guess I would also point out is that currently the court does have plenary authority. I don't think there's anything missing from that statement, from that concept, that means that this is not an agency or an entity with supervision, government supervision, by an elected court. So for folks who are pushing in that direction, I think you should be cautious. There's a lot more at stake than maybe meets the eye.
I understand. Oh, Fred, I'll let you respond.
I won't debate it now, but as a member of the bar for 35 years, I'll just say that I disagree with you on much of what you said. And I look forward to the opportunity to discuss this further.
Okay, and that's all I was going to say is at this point, I don't think any suggestion by any task force member as to things they would like to discuss should be, you're welcome to comment on it, but I don't think we're vetoing anything at this time. I understand Paul to have a view that if we were to have a discussion, he's expressed a view, but I don't think his expression of a view would mean that that is not a topic that the group will discuss and have at that time. So I welcome all. I would take Paul as saying we should not allow amendments to the WSBA bylaws to be approved by the Supreme Court, and the removal of the ED and the Discipline Council should not be overseen by the Supreme Court. Would that be correct, since that was your response?
Well, I'm not sure I entirely understood that.
All right, well...
The bar is overseen by the court at this point. And there's some things that have been left with the Board of Governors. And I think that in the interest of having an integrated bar, that's critical. Without that, I don't think an integrated bar is possible anymore. And I think there's a lot more at stake to that in that concept than maybe folks realize.
Okay. Well, I understand a request to have further discussion. I heard a disagreement with getting there. I did not hear agreement that the opposite is his view. And so therefore, I think I welcome everyone to present items they think would help us get to a place which we haven't gotten to yet, even deciding what we think we would want to do or not do to put ourselves in the best position for what the U.S. Supreme Court might at some point do and how we should look going forward. So other suggestions for questions, discussion, or future agenda items? Eileen, thank you. No, Eileen, I want you to raise your hand, and I don't want you to make faces like, oh, I'm raising my hand again. Active participation is welcome. Eileen, and then I'm going to Hunter.
Well, anyone who knows me knows I actively participate.
As do I, so I welcome it.
I'm taking a step back. I know these are controversial positions, and as a member of the bar also for 30-plus years, this is a difficult time of change. And I wanted to be sure that I'm starting from what I understand after having heard the presenters, excuse me, is that we have sort of three shoals to navigate, if you will. I mean, this seems to be, this is how it looks to me, and if others are saying I'm way off base or out to sea, whatever, then I'd want to know. And to me, the first is, and the most Washington-centric, is the fact that there is legislation to repeal the bar. The session is going to end, I think, in the middle of May. So, and the legislation has passed the House. It would have to go to concurrence with the amendments in the Senate. But that if this group were to have any input on the legislation, then would we have time to do so in terms of being effective? That's sort of the first thing to me that is a question. And then the second is Janus. I mean, this bar has been, during my decades as a member, veered from various issues, but has taken positions. And some of them I agree with, some of them I don't. But to me, the biggest thing in Janus is that ability, if it remains a mandatory bar, will probably be circumscribed in some way as yet not to be determined. The last I would like to follow is that the issue of the antitrust, I heard one of the presenters or someone here say it seemed to be the biggest issue, and I'm not an antitrust person, but to me, after the presentation from Jean McElroy and Mr. Ende about the impact on an individual's ability to make a living being dependent on the Supreme Court order, I thought made a difference in terms of antitrust. But that doesn't seem to be the perception here. So I would like to know a little bit more about that particular aspect and why I'm missing that it is such a great concern. So I just wanted to put that out and say that's where I am starting. But if that is not, if I've missed something or people feel very strongly there are other issues, then I'd want to know that when we start the discussion and when we ask for additional information.
Okay. Well, I have re-looked at my Supreme Court work group on the WSBA structure, and our charter was to review and assess the WSBA structure in light of 1, recent case law with First Amendment and antitrust implications, 2, recent reorganizations by other state bar associations and or groups and their reasoning, and 3, the additional responsibilities of the WSBA due to its administration of Supreme Court appointed boards. So that is our charter from the court. The work group, as desired or needed, will invite input, which could be information or opinions, from those with subject matter expertise on issues involved in review, assessment, and potential recommendations. And based on this review and assessment, the work group will make a recommendation to the Supreme Court as to future structure. For example, whether to maintain the status quo, semicolon, divide into 2 organizations, 1 mandatory and 1 voluntary, semicolon, or do some sort of hybrid where still 1 per organization, but perhaps with 2 governing bodies, 1 for the mandatory and 1 for the voluntary. There may be additional suggestions that the work group suggests or considers. So that is our actual charter that we're doing. I think the legislation came up after this, the Supreme Court has not taken a position on it. We are a Supreme Court work group, and the session is scheduled to end on the 28th. If they go into special session, which who knows yet, then it could go longer. So the only position the court has taken was to say if the legislation passes, to have a longer effective date, which was out, I believe, to January of 20, no,
In the current form of the bill is July 1, 2020.
July 1, 2020, which the court asked for, recognizing that if it was 60 days past sine die, that would be very quick, and also wanting to be sure that there was enough time for whatever we were doing to happen. So that's your first point, Eileen. Your second point, I definitely is related to Janus and the antitrust. So that is clearly within our direction. Other thoughts, comments? Oh, I'm sorry, Hunter was next. I apologize. On my list. Just have to look at it.
Thank you. So I will echo the comments both by Eileen and Andre on antitrust. I don't know anything about it, so I look forward to getting a lot smarter on that subject as this develops. I do have a comment on process, and this was largely summarized in the email that I sent after the last meeting to the Chief Justice and to Dory, and so I wanted to pass it along here for folks' consideration and conversation if they felt so appropriate. It strikes me as we're doing this that regardless of whatever our eventual recommendations are, I think it's really important that there be broad consensus within the profession that this process was a really good one and that there was a broad-based effort to receive feedback from the members and from the public. And this feeds a little bit on a comment I made at the last meeting, which is that I hope there will be time set aside in a future meeting to hear specifically from members of the public, and I would submit that might be best at the end of the information gathering phase, but before the deep dive phase, when we go into the different models that have been laid out there. But I just think it's important to hear from the members of the public on this and give them some dedicated time to talk to us. Related to that, I think it's important that we set aside some dedicated time to hear also from the members of the organization, the folks who have been dues-paying members of the organization because they're required to, for a long period of time, have a period of time at one of our future meetings where they could talk to us about these issues. I think a good step in that direction for people who might not be able to come here personally to talk to us is the email, the dedicated email address that's been set up, and I would encourage us to think about maybe trying to send that out to the members with a request for feedback so that feedback can be compiled for us to review. I don't think it's feasible for us to respond to everyone. I don't think that's a burden we should take on. But I would like to read what members and the public have to say. And then the last one is I would encourage us to think about soliciting written feedback from a various group of individuals who, by dint of past leadership in the organization or within the profession, I think might have a unique viewpoint. And this list is by no means exhaustive. It's just something I put together as I was drafting the email for the Chief Justice. But I would be I'd be interested to hear what the deans of the 3 law schools have to say on this. I think they're stakeholders in this. They're producing new members of our profession every year. The County Bar Association presidents, I'd be really interested. They're voluntary organizations. I'd be interested to hear what they think about the relationship with the WSBA and their existing organizations, how their organizations function, and if they have recommendations for us. The county prosecutors, I think, would be interesting to hear from. Our former Washington Attorney Generals. If we could get feedback from former Governor Gregoire, Rob McKenna, individuals like that, I suspect they have thoughts. And I should mention for a lot of these individuals, they may just simply not provide any written feedback. I get that. But I think there might be some who do. Our U.S. attorneys, certainly the section leaders, I'd be interested in their perspectives, the tribal chief judges, and our former WSBA presidents. And then the last I had on my list was the committee chair and the ranking members of the various committees in the legislature who are looking at 1788. These are individuals who spent some time thinking about these issues and, again, have records of service in the profession. So I throw that out there for consideration. This list is by no means exclusive. but I wanted to submit that. Thank you.
Story to respond first to Hunter, because we did receive your letter. I had meant to bring it up myself. I'm sorry I didn't pull it out of my binder, but Dory has already begun some of those inquiries, and so I'll have Dory respond, and then I'll come to you next, Mark.
So, Chief gives me more credit than is due in some respects. We did originally create the email address, thanks to the good work of Margaret, contemplating that would be a conduit for members of the work group to send questions that you had about the information that you'd receive, and that we would take the questions received there, send them to the presenter. Once we had the answer back, populate those to kind of a question posed, answer received kind of mechanism. Based on your input, we thought, okay, well, maybe we can expand the utility of that particular email address and also welcome input or comment flowing to us, recognizing that we will probably lack the capacity to respond to anything posed as a question on that forum, but we certainly would want to receive input or comment from whomever is inclined to use that email address and send it in. Which is why the chief announced the email address here. We can also push it further, including links on the website, and use it for that purpose. Again, with an idea that we will post what input we receive to a place on the website that you are, as work group members, made aware of, so that you can read through it and assimilate it. You take the suggestion a significant step further and are recommending, as I understand it, a couple things. One, an opportunity on the agenda where we have someone, a member of the public or anyone who wants to join us here. I think that provided we do a careful job of announcing, both on the web page and in our next meeting, for example, when we contemplate that being an opportunity, we can do a certain amount of that. I am mindful that the size of the room is what you see here. So nonetheless, wanting to make that opportunity available. Finally, you named a careful number of individuals who have leadership roles in the profession, and the opportunity to engage with them specifically to welcome their input. You mentioned how they may or may not send such input, but we at least can do that sort of outreach. And so that's the piece of it that we'll take back and try to construct the infrastructure for, because I'm imagining some of the individuals you mentioned may or may not have an awareness of this work group's efforts and the kind of materials that you've seen so far. So we might be hitting them a little bit cold with, hey, what do you think? So there might be a little bit of introduction that we can do to what you've been studying so far, to kind of prime them for what we'd be interested in hearing from them.
So before I go to you, Mark, my recollection, two things. One, Hunter, is that your list was more comprehensive than what you just outlined. So perhaps you have shortened your list a little, or maybe I'm just misremembering. And I also thought that you had already reached out to one of the law school deans. Other than the associate dean who was here?
Correct.
Okay. So maybe that was a disconnect on my part. I thought you were sort of starting down the list. And we thought a few people on your list maybe weren't appropriate because of a role they might play later. But I think my recollection is we wanted to bring it to this group. If this group thinks that would be helpful for us to do a targeted mailing to identified people to specifically invite their input if they choose, we can undertake that. So I would want to have a sense from the work group if that would be helpful. That is another big sort of effort on behalf of Dory and Cindy to do that. But I do think it is very important that we be transparent, open, and inclusive. And to Hunter's comment about letting them hear, like, before we go too deep, I would like to hear from those who already are pretty up to speed before we go too deep, who want to give us input. And that might even be at the end of the meeting on May 6th. And then I would think when we start kind of maybe coming in on a handful of recommendations, or one or two or whatever, but hopefully something manageable, that as that starts fleshing out, then we would hear from them about specific ones. So I sort of see two responses. One is like, hey, before you do anything, you should be thinking about this, sort of what we just heard from Paul in response to Fred's suggestion. So you're just getting input on in general. And then with that input, then as we would come back again. That's what I wanted to say, Hunter, and then I am coming to you, Mark.
Yeah, just very briefly, as an initial matter, I recreated my list of potential recipients of the letter from memory. So I think I probably did leave some off, and I forget which ones
That's
they
all
are.
right.
But as far as the mechanics, I've spent a little bit of time thinking about this. What I would propose if we went down this route, we may very well not. But if we did, I would propose just a very basic one-page letter that lays out the mission of the work group, and then lays out essentially the questions that have been posed to us, and solicits their feedback, and simply says, as a past leader in the profession, we wanted to invite your specific feedback, and maybe mention, if and when if there is going to be time for public comment or member comment, they would certainly be interested in hearing from them personally, but if they're not able to make it, then written feedback would be appreciated. And again, I recognize for a very significant number of these, they may just have no interest or no time, but if some of them did, frankly, I'd be interested in hearing from them. Sure. Thank you.
It's a compilation of figuring out how to reach them all, but it is a new day and we can figure it out. Mark?
I would just like to add, this the minority and specialty bar presidents absolutely have to be brought into this, and I think it'd be very important to bring in the executive directors of at least the major civil legal aid organizations, Northwest Justice Project, Columbia Legal Services, Northwest Immigrant Rights Project, some of the county bar pro bono organizations. That's the boots on the ground. And when Paul talks about the disconnect between many members in the state bar, I noticed that back 10 years ago when I was interviewing with the minority bar presidents to become the president of this bar. They didn't have a lot of interest then, and they were much more attached to their individual, the Latina bar and Lauren Miller bar than the big bar. So. We would be really, it would not be good if we did not at least invite them to the table.
Okay. Great. Other suggestions or thoughts? And also, I would like feedback on Hunter's suggestion, going to Eileen and then Esperanza.
I just, to sort of underscore that, but who's been missing would be all the public defender agencies. Those are constitutionally mandated services. The court has made clear that clients cannot pick their own lawyers, and there are rules and standards in place for them. So any reach out, I've been waiting for somebody to mention them, needs to include them, and I'm happy to help you getting addresses, places to go, listservs, things like that, if that's how we decide to go. I personally probably wouldn't be that much in favor of an open mic. I mean, I don't know what it would get us, but that's just my opinion.
Esperanza.
I would like just to follow up with some of the suggestions that we include the Pro Bono Council so that all 17 organizations are part of this.
All right. Based on the comments I have heard so far, it appears, at least from those that have spoken, that they are supportive of us doing a more targeted outreach to the groups that have been identified. Consensus-wise, does anyone disagree with that or would like to speak sort of toward us not doing that? All right, not having heard that, I'm going to ask that those who have made suggestions first do two things. One is I've made notes, but you know who these people are, many of them. And I know there's a specialty and bar association list that the bar keeps that has, or at least did, who have the presidents and those people. But to the extent there's a public defender list, or there's the pro bono list, or we can find the others. So if members would write to Dory, CCing Cindy Phillips, do you want to be CC'd, Margaret? And Margaret. So that means not Mary. Well, I'm happy to be CC'd, but this is where the magic happens. And my Cindy in Olympia, we will gather that, and we will start pushing out to them a one-page letter as described, which I think is all we need. Where's my Hunter? There. And just outlining it and inviting them. I think today is April 8th. Our next meeting is May 6th. I'm not sure. Well, I think, what do you guys think? Do you think we should try to have their input before May 6th? put them on a short leash, and if they're going to respond, they're going to respond, or they're not. We'll have some response. Yes, Esperanza.
So I need the data from them.
Right. So within a week, so like today is Monday, so ideally by Friday, you have your input to them so we can push it out. And we'll have the stuff ready to go, so as it comes, we can just start sending it out. And then we'll ask them to have it back by like the 5th. Okay, not like our meeting is a Monday, that Friday, the 5th. No, everyone's just going to read it. Oh, what do you want them back by? The 1st?
Yeah, our meeting's May 6th.
Oh, it's May 6th. I thought it was May 8th. May 6th. So it would have to be the May 3rd. And you guys can all read over the weekend and whatever we have. And then we won't have them come speak. We'll know what they have. Based on what they've said, we might invite them to come. And we will have time to be working through that even sort of together, what people found interesting, not interesting, how it's forming our thinking. Does that sound like a plan? Okay. Perhaps we can have them have it back by May 1st, but I want to give them enough time to also respond.
Right.
So-
That's true.
so-
We have to have enough time to get it onto the webpage for them. So Margaret and I will work really fast to load it.
All right, so let's say May 1st. Okay, so you guys, as soon as you have it out, we'll start pushing it out this week. Then we'll ask for a response by May 1st. As things come in, we'll just start posting it, so you guys can just see what's there. And then, and that'll be posted for the whole world to see, right? It'll go into the whole world to see group. So everyone can be looking and thinking, and then we will come, in addition to at least one, hopefully two presentations, we'll start working through that and seeing if there are themes, seeing if there are thoughts, seeing who we haven't heard from that we might want to target. That, well, gosh, we didn't hear from any of this group. We're going to revisit it. Maybe it was too fast a timeline, or we're going to confirm that they really aren't weighing in, that they are standing aside. Okay? All right. I have the ones I wrote down, so I would like to ask the bar, so I'm going to smile at Tara, and I'm going to call on you, Nancy, come up to the mic. Section leaders, the tribal chief judges, Jane, can you take care of them? Former AGs, we can get them off the list. The county prosecutors, we can get through WAPA. Public defenders, we will get from Eileen. From Esperanza, we will get the legal services people. Mark, you're going to bird dog the minority and specialty bars, even if you're just getting it from the bar, but you'll be in charge of that group. Legislators, we can decide, and the deans of the law school, we can do. So I guess I'm just asking you for the sections and the former bar presidents, please. Nancy.
When this discussion first started, I think you, Mary, had suggestions for maybe later in the process, or someone else said that this input might be more helpful when they had a variety of proposals to be thinking about. And that's the position that I think is an appropriate one. Because when I think of all the people that were named, and they're all people that might have points of view about the Bar Association right now, I doubt that any of them have read any of these cases or know anything about what's going on in other states, because it's not in their wheelhouse. It's not their topic. So what have they heard about the Bar Association in the last 6 months? They've heard there's sexual harassment lawsuits. They've heard that the executive director got fired and it's controversial. They've heard from some people that the Bar Association used to be out of control and now it's under better control, or it used to be under better control and now it's out of control. Everything that, and of course that the legislature is trying to eliminate the Bar Association altogether. That is what 99% of the outside world, if not 99.99%, knows about the Bar Association. They know nothing about these issues. And yet we're asking for their input. So what kind of opinions are they going to give us now? They're going to say, oh, I didn't like what happened with Paula. I don't like such and such. I wish the Bar Act still was in place. They're not going to be in a position of giving the kind of information that this group really needs at this point. I think a much more productive time to ask their opinion when they can really offer an opinion that's educated would be after this group does its preliminary work, has some of its preliminary proposals, and then we're asking them, don't just give us some comment out of nowhere. Here are some concrete ideas. Because the changes that may or may not have to happen, certainly the decisions about recommendations, are not a popularity contest about whether someone has felt alienated from the Bar Association or whether they want their dues to be lower. These are much higher structural issues, philosophical issues that need to be really addressed in detail as you are doing. And so I would urge that we go back to postponing some of this input to not only when it's more as best helpful to this group, but when those other stakeholders are in a better position to give advice.
Thank you, me, and then, thank you, Nancy. Me, then Andre, then Mark, and we have 5 minutes, so I'm going to be brief. Nancy, I completely hear what you're saying. The reason I am going to continue to advocate that we do this now is because I completely agree they may know nothing. But by sending them this first inquiry, it wakes them up. And then when we go, this will be the same, I would recommend this will be the same group we will at least go back to that says, now that, thank you for writing or not writing, because we're not going to necessarily respond to them. And we're going to say, don't expect a response from us one way. Then when we have it, we would go to the same group and say, okay, here are our proposals. So rather than hitting them cold in 3 meetings, we'll hit them cold now. They'll do something or not do something. And then when we come back, they'll be like, oh, 1, the bar structure work group cares about me. And 2, now I have something to work with that I didn't have before, and I'm going to have input. So that's my thinking of a 1-2. Not that we might get something, but we might get nothing. But what we get is a beginning of a conversation that we want to have with them. Andre and then Mark.
I'll be brief. Thank you, Chief. I echo exactly what your thoughts were with respect to the public sentiment and what people may know, but we've got to get the stakeholders invited to the table. And that's what the initial communication is. I think Chief has adequately described the thought process, and I support that. And so, Hunter, it would be a friendly amendment to your motion that this is a preliminary communication, not asking for their position on the structure of the bar, but necessarily, hey, we want you to have a seat at the table. What are your thoughts?
Mark and then Dory.
Very quickly, I agree with the Chief, and I agree with Andre. Here's the thing. As I read our charter, the Janus, Keller, all that stuff, that's going to be handled by the U.S. Supreme Court at some point. But we have to be also responsive to our members. What kind of bar association do they want? Do they not want any voluntary components? We don't know that. So if we don't listen to them, we're only doing half the job.
All right, Dory.
And I would just note, with respect to the suggestion made by Hunter about the mechanics to how to communicate the message, I think there's really an opportunity there for me when I push the solicitation for input to recite some of the language from the charter that frames what kind of input this group is looking for. And I can adhere pretty closely to, quoting out of the charter what we're tasked with here to invite, hopefully, a fairly sophisticated audience receiving this to respond on topic at least. And then the other safeguard I'd point out is it's a pretty engaged and bright bunch we have here, kind of sifting through what we get as input. You guys can probably sort through what sounds like it's on topic for the antitrust and First Amendment considerations that we're working through.
Well, and I also, I'm sorry, Sarah, was your hand up? Then you'll come up to the mic, but we have 2 minutes. What I think is that we also are able, I would like to include the meeting agenda. I would like, in what we push out, I would like to push how you can watch us live. I'd like to push out where the thing is. So I want it to be both asking for their input, but also, hey, by the way, we're underway, and these are ways you can pay attention if you want to. Sarah?
So that's a good segue. I was going to say, in just about every communication channel that we're working through right now, I think there's always a mention of this work group, like it has gone out in so many ways. So every bi-weekly email that every member gets. It's always in Northwest Lawyer. It's front and center on our outreach and engagement speaking notes, so it's going to bar leaders, and we got the webpage up. It's in columns. So we're doing our best to do just what you said. You know, there needs to be awareness. People need to know how to tune in. We've heard it's going to be on TVW, which is amazing. So again, we just need to make sure our goal right now, and we can never be breaking news even through Northwest Lawyer, but it's happening. Here's how you see it. Here's where the resources are, and here's some of the background. And when there is a thing, we just talked about it today, we're going to write that up and we'll put that out so people can push back
Right,
on
and
that
I
as
think-
well.
Thank you, Sarah. And what I think we're adding by this piece that Hunter has suggested and the work group has affirmed is specifically inviting input. So it's one thing to say this work group's working and what we're up to. It's another thing to say we try to be really representative. You look around this table, we have, I think, a really great, diverse group of people having this conversation, but we are only a tiny subsection of the larger bar, and we want the larger bar to know that we want to hear from them if they want to speak to us, and that's what we're inviting. Okay, I have 4:00. Unless someone else has something, if anyone has any future agenda items or feedback on how the meeting went or how I ran it, please send them to us. Otherwise, we are adjourned. Thank you.